moving on to Aisha. Kenya has been notoriously in the world map. If we start with the duty-free case, world duty-free case. But perhaps you could speak to the role of courts in your jurisdiction, and in particular, we've seen the developments the last 4 years as to appeal decisions.
First of all, I'd like to object to the use of the word notorious. Kenya has helped the international jurisprudence by creating a lot of its own to the benefit of all of us. And in terms of developments, I would say that Kenya is very arbitration friendly, contrary to some of the survey respondents. And this is because our new constitution of 2012 has embedded arbitration in our legal framework. So there's actually a legal duty on courts to promote and encourage the use of ADR, and it specifically mentions arbitration. So actually, it's a fundamental principle of ours that arbitration actually aids access to justice and should be supported by the courts. Secondly, the judiciary have really embraced this because we have a huge backlog of cases spanning over 10 years. And so actually, as a means of unlocking that backlog, they are trying to encourage as many parties, irrespective of what the contract says, to consider the use of ADR, for example, mediation, even if it's not in the contract. And whenever they have a chance, our Arbitration Act of 19, which is based on the UK Arbitration Act, it requires courts to automatically stay court proceedings where there is a valid arbitration agreement. Send the parties away, then they can come back to deal with any ancillary issues that might remain. Courts then have very limited intervention in accordance with the New York Convention on very well understood grounds. Now, what has happened recently, and I think you're thinking of the Supreme Court decision in Nyutu, is that there is an interplay between the Arbitration Act and fundamental rights, including access to justice and fair hearing. And this is being tested as part of our contribution to jurisprudence. We are very litigious, so we have to test all this to understand what does it mean for us. So there have been a number of cases that essentially challenge the Arbitration Act's insistence that decisions by the High Court on recognition and enforcement are final. So that decision is final. That would apply in 99% of commercial cases. However, there is this very rare case, which the Supreme Court has said every so often you have an exceptional decision where, from an access to justice standpoint, you would be allowed to apply for permission to appeal the decision on set-aside or recognition to the Court of Appeal. That is looked at quite carefully, and it may be that that decision is even appealable, again, if you apply for permission, which is almost never granted in commercial cases, but once in a while. In this case, they were given permission to appeal on an access to justice issue. And the issue in the Nyutu decision was because there was an award by a sole arbitrator on a breach of contract claim. And the award, which was a huge amount, was based on tort. So the argument was that the arbitrator had strayed outside his terms of reference by awarding tortious damages when essentially the claim and the pleadings were purely based on contract law. And this was an access to justice issue because the High Court judge was being told, if you recognize this award, you are insulating this decision, which is very unfair, obviously against the losing party. It's very unfair. You're unfairly insulating that decision and preventing access to justice because the tortious claim was not pleaded. It was introduced by the arbitrator in the award. So you can understand why that's fairly unusual and unique. And so in that instance, the award was set aside. Now, under the New York Convention, that would have been the end. So it was an unusual situation where finality of award meant no award at all, which doesn't help the parties because how do you resolve the dispute? You have an award, it's been set aside, and you're being told you can't appeal. So in those very limited exceptional cases, they were given permission. they were given permission by the Supreme Court to appeal that finding on set-aside to try and actually resolve the dispute. And essentially what the Supreme Court said was it was not open to the arbitrator to award damages on a claim that wasn't pleaded and wasn't covered by the scope of the arbitration agreement. Now, that has opened up a new line of cases, which is that what losing parties are doing in Kenya at the moment is they're saying that essentially, okay, so to get around the arbitration agreement when they don't want to be forced to arbitrate is to introduce constitutional claims and criminal aspects. So they're saying where we're pleading criminal liability or basically criminal fraud and fundamental breaches, then obviously those are not arbitrable. And this has gone all the way up again to the Supreme Court. And the Supreme Court has said, the case that went to the Supreme Court said involved third parties. So there it was very clear that the Supreme Court said you obviously can't force third parties to arbitrate because the whole basis is consensual. What is left hanging is, okay, so you have an arbitration agreement and you have non-contractual claims that aren't covered by the scope of it. You would not be able in Kenya to essentially adjudicate fundamental rights in arbitration. It's a private process. It's not there to establish fundamental rights. So we are seeing a lot of this being tested, but the reality is even though Nyutu appear to provide an avenue to appeal, all the people who sought permission to appeal have been declined. So it's almost like what our speaker said previously. Ignore the paper and look at the ground. So on paper, there is potentially in 1% of cases permission to appeal, and on the ground you won't get the permission. So I think we're very arbitration friendly. Thank you.